The Appellate Division First Department is now in session. Good afternoon and welcome. Before I begin the call of the calendar, I would ask that everyone join this court in taking a moment to honor the legacy and life of our brother, the Honorable Paul Feynman, who we lost this morning. Thank you. And now for the call of the calendar, I ask counsel, please pay attention and answer when I call your case. People versus Jeffrey Taylor submitted. The case of Ferraro versus McGovern. Counsel for appellant.
Present.
I understand there's a pro hoc vici application. Counsel, I will hear you on that application.
Yes, I'm Jim Ferraro. I've been a member of the New York Bar for many years. And I represent Matt Gutierrez, who will argue on my behalf, my partner at my law firm, the Ferraro Law Firm.
Very well. That application is granted. Mr. Gutierrez.
Good afternoon, Your Honor.
Welcome, and you've been granted 4 minutes and one unless respondent is not here. Respondent's counsel, are you here? Hearing no response. Mr. Gutierrez, you have 4 minutes, and you will be the first on the calendar.
Thank you, Your Honor.
H. Kenneth versus Lauren S. submitted. Bateye versus New York Developers. Counsel for plaintiff. For appellant.
Hi, present. Douglas Jadomski, Hanem Fairtech, Prendergast, and Merlino.
And you are respondent, correct?
Oh, no, I'm the appellant.
You're appellant. You are for New York Presbyterian?
No, I'm from New York Developers. And
I'm sorry, I'm reading from the wrong line. Forgive me. New York Developers. Okay. And counsel for respondents?
Good afternoon, Your Honor. Jillian Rosen for the plaintiff respondent.
Good afternoon. You have 5 minutes. And Big Apple?
Lisa DeLindsey for Big Apple.
Good afternoon. You have 2 minutes.
That's fine. Thank you.
Global Liberty versus Cambridge Medical is submitted. People versus John Torres is submitted. Young Bora versus New York Presbyterian. Appellant.
Barbara Goldberg for appellant, New York Presbyterian.
Good afternoon. You've been granted 3 and 1. Respondent.
Robert Godowski for the respondent.
You've been granted 3 minutes. Good afternoon.
Good afternoon.
YRN LLC versus Migos LLC. Appellant.
Good afternoon, Your Honor. Stephen Popovsky for the appellant.
Good afternoon, Mr. Popovsky. You've been granted 5 and 1. Respondent.
Good afternoon, Your Honor. Sarah Matz for the respondents.
Good afternoon. You've been granted 5 minutes. Estrella versus East Tremont Medical. Appellant.
Yes, Your Honor. Manuel Gomez.
Good afternoon. You've been granted 4 and 1. Respondent.
Good afternoon, Your Honor. Darren Ratner for the respondent.
You've been granted 4 minutes. Gambagolta versus Che. Appellant.
Good afternoon, Your Honor. Colin Rath J for appellant Ron Che.
Good afternoon. You've been granted 4 and 1.
Thank you.
Appellant SIU Hospital.
Daniel Lay for defendant appellant Staten Island University Hospital.
Good afternoon, Mr. Lay. You've been granted 3 minutes. Respondent.
Good afternoon, Your Honor. Marcia Rakes for the plaintiff respondent.
You've been granted 5 minutes.
Thank you, Your Honor.
Good afternoon. People v. Ben Cosime is submitted. Lindenwood Village versus Dennenberg. Appellant.
Good afternoon, Your Honor. Joshua Kamens for appellant.
Good afternoon. You've been granted 3 and 1. Respondent.
Stephen Sperber, good afternoon, Your Honor.
Good afternoon. You've been granted 3 minutes, sir.
Thank you, Your Honor.
Lopez versus City of New York is submitted. People versus Eric Wilson is submitted. Leasing Control versus 500 Fifth Avenue. Appellant.
Good afternoon, Your Honor. Mark Zauderer for appellant.
Good afternoon, sir. You've been granted 3 and 1. Respondent. Respondent.
Turner Smith for the respondents.
Wonderful. 3 minutes. Drawn versus Roker. Appellant.
Good afternoon, Your Honor. John Smargiassi for the appellant Everett Drawn. I am local counsel in this matter, and I'm going to be asking to move the court to allow Mr. Ferdinand Valteau to argue the case today. He is a member of the Bar of the State of Louisiana. He was previously admitted pro hac vice in this matter, and he also is the primary author of the brief in this matter.
Thank you. And that application has been granted. Welcome, Mr. Valteau, and you have been granted 6 and 2. Respondent.
Thank you, Your Honor.
Respondent. Mr. Stratcher, if you're trying to speak, we cannot hear you.
Sorry, apologies, I was muted. Cameron Strucker for the defendants, respondents, Al Roker Entertainment, Jennifer Lopez Entertainment, New Yorkin Productions, Inc., Bodega Pictures, LLC, and Viacom International, Inc.
Thank you, counsel. You've been granted 5 minutes. Conway versus Kaplan, counsel for appellant.
Yes, Ron Mukherjee here for the appellant, Lisa Conway. Good afternoon, Your Honor.
Good afternoon. You've been granted 3 and 1, sir. Respondent, counsel.
Daniel Ditchweiler for respondent Howard Kaplan, Your Honor.
Good afternoon, and you've been granted 3 minutes.
Thank you, Your Honor.
Good afternoon, Mr. Gutierrez. We will hear you for 4 minutes. And before you begin, is Mr. Daniel Flynn present on this call?
Your Honor, I have to represent to the court. Just this moment, I received an email from Mr. Flynn indicating that he's having connectivity issues.
Good afternoon, Your Honor. This is Daniel Flynn. I'm very sorry for my tardiness. My computer with the webcam died. Our office internet went out, and I've been trying to join the call on my phone, but I am here.
I am so glad you are, and it's okay that you are on audio. You have 4 minutes. Mr. Gutierrez, you have an additional minute on rebuttal, and the floor is yours for 4 minutes.
Thank you, Your Honor. May it please the court, Matthew Gutierrez on behalf of the plaintiff appellant, James Ferraro. This appeal presents a very simple question regarding the sufficiency of summary judgment evidence. In this case, my client, who owns a condominium, suffered a water leak that occurred somewhere above his unit. In this building, the only unit above his is the one that's owned and occupied by the defendants. That unit, owned by the defendants and occupied by the defendants, also happens to have a bathroom that's directly above the water dam.
Excuse me, counsel. This is Judge Mazzarelli. Are there any other machine rooms or any other rooms that belong to generally to the building above your client?
To my knowledge, no, Your Honor. There's plumbing that was inspected and was not and determined to not be the source of the leak. And the roof above the McGovern unit also was determined to not be the source of the leak.
Thank you.
In this case, the trial court entered summary judgment on 2 very narrow specific grounds. Number one, the trial court determined that nobody identified the McGovern unit as the source of the leak. And number two, the trial court determined that Mr. Ferraro did not provide any expert opinion supporting a finding of causation that the defendants caused the leak. Both of these findings are patently erroneous and ignore the dispositive evidence in this case, which is the sworn declaration of Kurt Friedman. Mr. Friedman is Mr. Ferraro's expert witness, and he provided a declaration which attached the supplemental expert exchange in this case, which disclosed two pertinent opinions by Mr. Friedman. Number one, Mr. Friedman identified numerous defects in the tub and the spigot that is directly above the unit, Mr. Ferraro's unit, that caused water to leak directly next to the bathtub and puddle onto a 3-inch by 1-inch opening that's covered by a loose metallic plate. That loose metallic plate is directly above the origination point of the water damage in the Ferraro unit. Number two, Mr. Friedman opined that it was more likely than not that the damage to the Ferraro unit was caused by an overflowing bathtub and or defective spigot. The only overflowing bathtub and defective spigot analyzed anywhere in his declaration and the supplemental response are the bathtub and spigot that are owned by the defendants that are directly above the water damage in the Ferraro unit. This evidence, seen in the light most favorable to Mr. Ferraro, clearly refutes both of the trial court's findings. It's interesting to note that the defendants make no effort whatsoever to address the substance of these statements. The closest they come is they suggest that the supplemental response, they purported to reject it because they say it violated CPLR 3101. CPLR 3101 is a discovery rule, does not govern summary judgments. And once an expert's opinion is reduced to evidentiary form, CPLR 3101 does not govern its admissibility.
No, and am I right that 3101 D, I'm assuming they are quoting, has no time limitation or restriction?
Correct, Your Honor. Yes, you are correct. And number two, the defendants make no effort to distinguish the two, in my view, dispositive cases in this case, which are the Pasta Bar case and the Towns case that are cited in Mr. Ferraro's brief. Those two cases make clear that an unsigned opinion attached to an expert's declaration is proper summary judgment evidence. The same is true here. Mr. Friedman incorporated the unsigned supplemental expert response into his affidavit and swore under the penalty of perjury that it was true and correct, and if called at trial, he would testify consistent with those opinions.
Thank you. You have 1 minute on rebuttal.
Thank you, Your Honor.
Mr. Flynn, you have 4 minutes.
Good afternoon, Your Honor. So to respond to Mr. Gutierrez's allegations, I want to just note that there are machine rooms present that are adjacent to my client's apartment, which is the penthouse of the building. Secondly,
how is the bathroom of your client is directly above the location of this leak, is it not? Or is that incorrect?
The bathroom is located above the Ferraro apartment, but it is
directly no, not just above the apartment. My question was whether the bathroom in question is directly above the original source of the leak. That's the question.
There's no proof as to the original source of the leak. There is some damage that existed in the Ferraro apartment, which happens to be below my client's bathroom. However, my client's bathroom is also immediately adjacent to the machine room of the building.
Well, how large is the bathroom in a penthouse apartment?
This particular bathroom is not very large at all. I have been there
What's
myself.
not large? I would
believe-
expect that an apartment and a bathroom in a penthouse apartment that's a duplex penthouse would be at least 1,000 square feet. Am I wrong?
You are wrong, Your Honor.
Okay.
The bathroom
So what is it?
The square footage of the bathroom is, I don't have the exact number, but I could tell you it's approximately 6 feet by 9 feet. So,
really,
it's
6 feet
about
by 9
64
feet?
square feet. It is a smaller bathroom, Your Honor.
A 6 foot by 9 foot bathroom has a toilet, a sink, and a bathtub?
It is rather cramped, Your Honor. As I said,
I don't
I've
even
been
think
there.
that is possible under the building code, sir. Are there photographs in the record you could point this court to that would substantiate what you've just said?
There are photographs in the record. They were submitted as part of the photographic report that was included in the.
Could you tell me what record number that is?
Give me one moment.
And I will give you an additional
I appreciate Your Honor. It's
time
pages
in order
189, pages 189 to 220.
Thank you.
You're
Proceed.
very welcome. As far as the opinion that Mr. Gutierrez refers to, which the court specifically addressed both in the decision for the motion for summary judgment and the decision for the motion on re-argument, the crux of what was relied upon by Mr. Ferraro was this photographic report, which you will be looking at momentarily. Subsequently, Mr. Ferraro submitted what was referred to as the supplemental expert disclosure, which does not contain an opinion unsigned or signed or otherwise, nor was it prepared by Mr. Friedman. It is a document that was prepared by Mr. Ferraro, I believe. So it does not have any expert opinions in it, which is why it was denied by my office. However, in the decision by the Supreme Court, it was specifically addressed, like I said, both in the initial decision for the motion for summary judgment and in the decision for the motion on the argument. That being said, Mr. Ferraro's appeal, again, is just an attempt to get a second bite at the apple. They've raised the issues that the Supreme Court had misapprehended facts in this matter, which was clearly not the case. The decision was very clear that it took into consideration all submissions by both parties, inclusive of the photographic report provided, which, as I said, you are looking at or were looking at, as well as the supplemental expert disclosure. Taking that into consideration, the court did determine correctly that Mr. Ferraro was unable to affirmatively point to the McGovern apartment as the origination point of the water that exists in the Ferraro apartment. With respect to the opening that exists that Mr. Gutierrez referred to, that is noted in the photographic report, the 3 by 1 inch opening.
Right, that was not at issue as it was conceded to exist.
I'm sorry?
It was conceded that it exists.
Correct. It does exist. It did exist at the time that the flood allegedly occurred, and I'm not raising any issue with that concession. But as noted in the underlying motion and in the respondent's brief, it is not an opening that would provide for the amount of water necessary to cause the damages alleged by Mr. Ferraro, nor is there enough water that would be flowing from the bathtub into that hole to cause said damage. It's also...
Thank you so much. I have given you 2 extra minutes in light of the questions I asked you. Thank you.
I thank you, Your Honor.
Counsel, you have 1 minute, Mr. Gutierrez.
Just to address a couple of the points, Your Honor, there is unrebutted evidence that the bathtub and spigot are located directly above the water damage in the Ferrari. If there is an adjacent water room, I'm not aware of it being in the record. And even if there were, and that somehow could call into question, maybe that was the source of the leak, that's a defense they could argue, but it doesn't negate the fact that we have evidence pointing directly to that bathtub and spigot as the source of the leak. Mr. Flynn just represented to the court that the supplemental response does not contain any opinion. The whole purpose of the supplemental response was to articulate Mr. Friedman's opinions. And he is once again incorrect. At no point did the trial court ever address the substance of the opinions that are reflected in the supplemental response. That's all I have. Thank you, Your Honor.
Thank you so much. Okay. Counsel for New York developers, Mr. Domsky.
Yes, hi.
Good afternoon. You have 5 minutes.
5 minutes, okay. Do I have any rebuttal or just 5 minutes?
5 minutes and 1 minute rebuttal.
Okay, thank you. Hi, good afternoon. My
Good
name is
afternoon.
Douglas Stofsky with law firm Hannum Fairtech, Prendergast Merlino. I represent defendants, third-party plaintiffs, appellants, New York developers, and 317 St. Mark's Avenue LLC. This is a labor law action. Our appeal
Counsel,
on
I
two grounds.
suggest you get to it. You don't have a lot of time.
Okay, got you. Okay, our contention on appeal is that summary judgment to the plaintiff should not have been granted because.
Excuse me, this is Judge Mazzarelli. What evidence is there in the record that the plaintiff speaks English?
He was in the country for 5 years and he took English classes.
Where?
He said he took English classes for several months. The name of the school wasn't in the record, but he has been in the country for over 5 years.
That means nothing, counsel. You and I both know it. There are immigrants from all over the world, not just Spanish-speaking countries, that live in this country sometimes for 10, 20 years and never speak English. So the fact that he's been here 5 years is meaningless. Where is the proof in the record?
Well, I believe that's for a jury to decide whether or not plaintiff understood the directions that was given to his foreman within an hour before the accident. The foreman gave unequivocal testimony that when given the instructions, plaintiff acquiesced, okay, put down his nail gun and shook his head as if he understood.
Did Mr. Rosenberg wait and observe the plaintiff getting down and going and get these guardrails, or did he come back and check to see if the guardrails were installed in proper fashion at any point before the accident?
No, he did not. Once plaintiff stopped working and put down his nail gun and acquiesced as if he understood Mr. Rosenberg's instructions.
Is that what he said? I understand? Or he just said, okay, and shook his head up and down?
Well, if I may quote to the testimony, it's in my reply brief.
The testimony of whom? Your client?
No, plaintiff's foreman, his direct foreman. Regarding
counsel, but plaintiff's foreman spoke to him in Spanish, not in English.
Well, no, that was plaintiff's.
Antonio Laura, his direct foreman, spoke to him in Spanish because that was the only way that Mr. Rosenberg could communicate with people on the job site, such as plaintiff.
Well, Mr. Rosenberg indicated when it came to sometimes with more complicated instructions, Antonio Laura was there to assist. But with simple instructions, he was often able to communicate that directly to the worker.
And get down from that scaffold because you can fall and go get railings that are located in the back of the building somewhere. Is a simple instruction that the plaintiff here, you are saying we should take as a absolute certainty that he understood.
I believe that's for the trier of fact to make that determination. And I believe it should be up to the trier of fact to determine whether or not plaintiff understood that instruction, or they're free to say, hey, you know what, that wasn't his primary language. I don't consider Mr.
Well, we know it's not his primary language. That's not an issue. Or are you contesting that also?
No, I'm not contesting that Spanish is his primary language.
Okay.
I'm contesting that it's up to the trier of fact to determine whether or not.
Well, we know, see, my difficulty here is we know that he required some translation for what you say would be complex instructions. Is that what I heard? Did I get that right?
Well, not to the plaintiff himself, but in general to a number of the workers.
But we're talking about the plaintiff. That's all we care about here, right? So
it's required to interpret for his deposition.
He did require an interpreter for deposition, but that's not dispositive of, hey, he doesn't know any English. And as I maintain, I believe that's up to the trier of fact to decide whether or not he could have understood these instructions. And there's reasonable circumstantial evidence upon which they could make a reasonable inference that he did understand the instructions.
By the way, counsel, do we know the exact words that were used by Mr. Rosenberg in communicating these instructions to the plaintiff? Or he couldn't tell us at the deposition?
Well, the sum and substance, he did.
The sum and substance.
Well, yes, he's being deposed about an event that took place 2 years before the date of the accident. So to expect him to memorize verbatim what he said when this conversation was recorded.
Well, there was an incident report, correct?
There was no incident report, no.
No? Oh, I thought there was. All right. So it must be another case I read. Sorry about that.
You know, I'm amazed at Mr. Rosenberg's acumen in knowing all of the various points to cover and attempt, you know, and giving you the groundwork to claim sole proximate cause defense. It's quite amazing how adept he was in covering all the different points.
Again, that's whether or not he's credible. That's something the trier of fact is to determine. Summary judgment's a drastic remedy, and defendants deserve their day in court for a trier of fact to determine whether or not they find Mr. Rosenberg's testimony credible. If they find his testimony credible.
Can you tell me just one more, because I think we've gotten your arguments on that particular part of the fact pattern. My question now is with regard to the wheels on the scaffold. Is there any evidence in the record that we have before us that someone contemporaneously with this fall actually checked the wheels on this scaffold?
Well, shortly after the accident, both Mr. Rosenberg and Mr.
I know the record. My question is very precise because you're out of time. So the question again is there any evidence in the record that specifically states by any of your witnesses that, or any witness for that matter, that someone checked this scaffold after the fall of this plaintiff and assessed the condition and positioning of those wheels, the wheels themselves, not observations about the scaffold? Did anyone check the wheels?
You mean other than just the visual observation that the wheel locks?
Yes, the claim about the moving scaffold. Other than that, did anyone actually check the scaffold wheels and their braking mechanisms, whether they were locked, put in the down position for locking?
It was a visual observation, not a physical one. Meaning they saw that the wheel locks were in the up unlocked position and not placed in the down locked
Where
position.
does it say up and unlocked position?
Yes, I thought the testimony was that the scaffold moved, so there was an assumption that the wheels were not locked.
Tell me where in the record it says up and unlocked position, because I didn't notice that in the record and I looked. So I obviously missed it. You know what? Why don't I give you time to try to search for that? You have 1 minute on rebuttal, and I will let your respondents have their time since we are out of time, okay?
Okay.
Ms. Rosen, you have 5 minutes. Ms. Rosen, you have, Mr. Douglas, Mr. Domsky, your time is up. You can respond to our question on your rebuttal. Ms. Rosen, you have 5 minutes.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. I can give you some record sites that I think will help clarify a lot of this. 917 of the record, Mr. Rosenberg does not remember word for word what he told the plaintiff. On 896 of the record, Rosenberg tells the plaintiff to go to the back, and he doesn't specifically say where these railings are. He doesn't bring the railings to him. He doesn't say, do not use the scaffold without these railings. He also, at 898 of the record, admits that he spoke to the plaintiff in English, and he also does not know at 898 of the record, if plaintiff shook his head yes or no in understanding. At 905 of the record, Mr. Rosenberg concedes that he never sticks around to see if plaintiff went to look for the railing because he left the area. So that is, defendant's recalcitrance argument actually defeats itself because there were no railings. Plaintiff testified, his testimony is unrefuted, that he asked Antonio for the railings, and Antonio told him there's no more railings. This is at 344 to 345 of the record. And plaintiff also testified that he asked Antonio if there are any more Baker scaffolds available. And at 350 of the record, Antonio told him there's no more Baker scaffolds available. So this is not a situation where something was readily available. This recalcitrance argument fails. With regard to the wheels,
does Antonio deny making those statements?
Well, no, Antonio isn't denying it. Antonio was never deposed, and the defendant didn't produce an affidavit of Antonio to rebut the plaintiff's testimony, which is the only testimony before the trial court, because the defendants didn't witness the accident, and so we don't have anything from Antonio. But the plaintiff established through unrefuted testimony, that he actually asked for the railings, and the railings weren't available. Nothing was provided to him. All we have is a scaffold that was inadequate because it was provided without the railings.
Is there anything in the record, excuse me, to indicate how high the scaffold was?
I believe he testified that he thought it was, I'm not so sure, Your Honor. I think that the testimony was more how high the ceiling was. I think maybe he testified it was 4 feet or 5 feet, the platform, but I could be wrong. I would have to check my notes, Your Honor.
Thank you.
With regard to the
Does anybody know where Antonio is?
Your Honor, I'm not sure. We thought that if there was anything to rebut on opposition, the defendant would submit an affidavit from Antonio. It's the defendant's subcontractor. So I can't answer that. Maybe my adversary can, but at this point before the trial court, when they decided the motion, the plaintiff's testimony was the only evidence before the court. I just want to hit the wheels before my time is up, if I may. At 928 of the record, Rosenberg testified he didn't check each wheel of the scaffold, and he never checked to see if the locks on the wheels were working. With regard to Mr. Friedman, who's the owner, he testified at 1102 to 1103 of the record, he never checked the wheels after the fact. I think that
so where does this comment of the wheel latches were up and unlocked come from?
I believe Mr. Friedman or Mr. Friedman said he waffled in his testimony. He said he may have seen at least one wheel that was unlocked. He saw a lever that was up. You could either see if it's up or down. He may have seen 1 out of 4, but his testimony equivocates at 1102 to 1105 of the record. And he does admit that he never checked to see if the locks were working. But to tie this up, as you know, just recently in Ordonez, this was a decision by this court last month. This is at 191 83rd 412, even assuming, which we're not saying this happened, but even assuming plaintiff failed to lock the wheels, this could only at most be a defense of comparative fault, which is not a defense to 240 subsection 1. And then given the scaffold's inadequacy, we have 2 layers of 240 violation. We have a scaffold that doesn't have railings, and then we have a scaffold that moved while plaintiff was working and failed in its core purpose to keep him from falling to the ground. So even if he failed to lock the wheels, which we're saying there's no evidence that he did, plaintiff was the only testimony, it was plaintiff's testimony as to what the wheels looked like, and that he locked all 4 of them, that's his testimony, prior to getting on that scaffold. At most, it would be a comparative negligence or comparative fault, which isn't a defense.
Thank you.
Oh, my time is up. Thank you so much for listening. Thank you.
Thank you so much. Mr. Lindsay, you have 2 minutes.
Thank you. May it please the court. Our position is that the summary judgment court correctly found that there was a question of fact as to whether contractual indemnification applied. Mr. Friedman testified that he regularly walked the job site, and so it's our position that he did have control over the safety precautions which was the scaffolding being used, and that he was aware that it had been used without guardrails in the past, and he was on notice of this condition, and he had the ability to stop work and to kick anybody off the work site that wasn't working. So it is our position that New York developers did not meet their prima facie burden, and that the lower court's decision should be left undisturbed. And unless there are any further questions, I rely on my brief.
Thank you. Mr. Domsky? the floor
Yes,
is
hi.
yours.
Quickly, I'd like to rebut. As far as the unlocked wheels, the record where you'd find that both Mr. Freeman and Mr. Rosenberg, shortly after the accident, looked and saw that the wheels were in the unlocked position is page 714, 738 to 739, 927, 932, and 1121 to 1122. Through 1121 to 1122. Question, you can see it that the levers were unlocked. It says locked and unlocked, and it was unlocked. So all the wheels were in the unlocked position. Answer was yes. As far as plaintiff's testimony is refuted by Mr. Rosenberg, and the guardrails, which was a safety device, was located on site in the rear yard. As far as the contractual indemnity argument, it's a means and methods case. It's equipment that was owned, supplied, and
Well, how
installed.
far is it from the rear yard that you just referred to where the accident took place?
It's 150 feet, and just as in Cherry v. Time Warner, as long as the worker is told as to the exact location where the safety device is located, and the safety device is located in the same area, then it is considered readily available. And workers had the practice of going to this area to retrieve the guardrails if they needed it for their Baker scaffold. So back to my contractual indemnity argument, it's a means and methods case. And even if notice is a standard, which it is not, Mr. Freeman was not on notice of this condition because on 2 prior instances, it was quickly corrected once Mr. Rosenberg was notified of it, and there were no further instances in the interim prior to plaintiff's accident. So New York developers would not have been on notice of it, and in addition, they did not have any contractual responsibility. Specifically, the construction manager agreement said they are not to be charged and in control of the means and methods of the subcontractor's work. And as we know,
Thank you.
it's Legion that.
Thank you so much, Mr. Domsky. Have a good afternoon.
Thank you very much.
Paula Young Bora versus New York Presbyterian. Ms. Goldberg, you have 3 minutes.
Thank you, Your Honor. It's our position that the area in front of the nurse's station in the ambulatory recovery unit where the patient slipped and fell was under constant supervision by the patient care attendants, by the nurses who were working there, and by the housekeeper. It was not just the witnesses who testified on behalf of the hospital, but it was all of the patient care attendants, all of the nurses who were there. Nurse Mitchell Keene, who was the patient care director, testified at page 405 of the record that it's the responsibility of all employees to be monitoring the area. She had been in the nurse's station for about 20 minutes. She last saw a visitor pass through the area less than 5 minutes before the plaintiff fell, even though she was not looking out at the room at the time. She would have noticed anything on the floor when she went into the nurse's station, based on the testimony that she inspected the unit on a regular basis. If she saw anything wrong, she would make a note or correct it. The level of supervision here with each person who was working.
So are you arguing that the statement, had there been something there, I would have seen it, is sufficient evidence and a substitute for the required testimony as per our precedent that I specifically looked down at the floor and saw nothing on the floor when last I was at the station?
Your Honor, I think that line of cases can be distinguished given the number of people who were working here and the testimony that they all had a responsibility to be constantly monitoring the unit. Mr. Caprietta, for example, who actually—
Yes, but most of these people were sitting down behind a desk. So it's not like they were walking around necessarily, or perhaps they were, but we have no statements from them to that effect. Am I wrong? Did I miss something in the record?
Well, I would say, Your Honor, that what we're overlooking and what I think the plaintiff overlooked in her brief is that it was not just the witnesses who testified. It was not just Nurse Mitchell-Keene. It was not just Mr. Caprietta. It was not just Nurse Brannigan and Mr. Fernandez. The testimony was that everyone who was on duty had an obligation to monitor the unit for unsafe conditions. And there were, according
I'm sorry, but how is that evidence that that's what happened here?
Your Honor, I think it's a reasonable inference. Nurse Brannigan.
Counsel, you know, again, based on our case law, we can't take reasonable inference on this issue.
Well, Your Honor, I would
like slip and fall. Am I wrong? Do hospitals have some special rule that we're supposed to follow on a slip and fall?
I don't think there's a special rule, Your Honor.
Okay, so then we have to follow the precedent of this court, which says that there's got to be at least some statement from the person or persons whose responsibility it is to check, and that they indeed did check prior to this fall. And we don't have that here.
But Your Honor, there's another line of cases that I would like to point out. And
all right, I'll let you point them out on your time on rebuttal. Okay.
Right, thank you very much, Your Honor.
You're welcome. Mr. Godosky, you have 3 minutes. We can't hear you if you are speaking.
Apologies.
No problem.
I thought I did that when I put my camera on. May it please the court. To reiterate what Justice Manzanet mentioned, certainly as this court has held, a defendant moving for summary judgment, carries the burden of establishing prima facie proof of entitlement of summary judgment, which they do not do here. And as this court's held, specifically must produce evidence of its maintenance activities on the day of the accident, and specifically that the dangerous condition did not exist when the area was last inspected or cleaned, citing to Ross v. Betty and Barrett v. Arrow, in addition to other cases in the brief. Even some of the people who did testify, while the general proposition was that they should all look, the fact is that the housekeeper, who was one with the mop, said he never inspected, wasn't part of his job. If he was told to do something, he would do so. In this case, if the defendants want to refer to all these other people, which are predominantly medical people, and admittedly there are some lay people there who have family or are being operated on in the ambulatory surgical unit, they could have submitted affidavits in their motion. They didn't seek to. They could have obviously taken depositions. One would have expected them to speak to everybody who would have been able to say exactly what Justice Manzanet said is the requirement. And they failed to do that. And as a result, they did not meet the burden of proof of establishing a prima facie case. Specifically, one of the things that was most interesting is that the appellant argues that, and they acknowledge that they could not produce a witness who could testify that he or she had specifically inspected the area in front of the nurse's station prior to the incident. I mean, that in and of itself causes a finding that motion for summary judgment should be denied.
Thank you. Thank you so much.
Thank you.
Ms. Goldberg, you have 1 minute on rebuttal.
Okay, thank you, Your Honor. The basic point here is that a verdict in favor of the plaintiff would be based on nothing more than speculation. Plaintiff cannot prove that an employee of New York Presbyterian Hospital was responsible for the water being on the floor, nor can plaintiff prove that it had been there for.
They don't have to prove. You moved for summary judgment.
But Your Honor, I'd like to call your attention to 3 cases.
Counsel, you have the burden of proof. So tell me what evidence in the record established your burden of proof on this case. That's the only issue before this court.
Nurse Brannigan entered the nurse's station literally moments before the plaintiff fell, and where she was coming from, she came from the other end of the room. She would have seen if there was any water on the floor. She didn't see it. She testified at pages 492 to 493 of the record, she did not recall seeing a puddle. Page 523 of the record, did not see any water or other substances on the floor.
What case stands for the proposition, I don't recall equals sufficient evidence?
There are 3 cases from this court cited in our briefs, Your Honor. The Warner
That
case
says, I don't recall seeing is sufficient evidence to establish your burden of proof.
They
That's
don't
what
use
those cases say?
that language, but they do talk about pure speculation and no evidence from which a jury could reasonably conclude that the wet spot upon which plaintiff slipped existed for a sufficient period of time for defendants to have discovered and remedied it. That's in the Berger case, which is cited in our brief.
We will
Also-
take a look at those cases again. Thank you, counsel, for your arguments.
Thank you.
YRN LLC versus Migos LLC. Mr. Popovsky, you have 5 minutes.
Thank you. The fundamental misconception of the court below was that the name the fashion brand was built around, Young Rich Nation, was only a song or an album. In fact, it was the emblem or shorthand defendants themselves had selected to identify themselves and their following, their empire, defendant's word. That's evident from section 11.2A, which obligated the performers to wear multiple Young Rich Nation garments at all live performances and at least 6 music videos per year for as long as the parties remained in business together.
That's all well and fine. How does that equal that somehow it includes the Migos brand?
It doesn't.
It's not a part of the agreement here, is it?
It doesn't include the brand in the sense that the plaintiff can use the brand.
No, not in any sense. Does it even mention the brand Migos in that agreement?
Yes, it says that they can't, it says that they cannot put the brand Migos on apparel. That's what 11.2C says.
On apparel that is YRN. It doesn't say any, counsel, it doesn't say anywhere in that language. And I ask you to tell me precisely which language does say that they are prohibited from using Migos label on anything.
11.2C, Your Honor, says.
That's not how I read it.
I read it to say of any item of the kind produced by the company under the trademark, Your Honor.
And the trademark is YRN, isn't it? Not Migos. The trademark is YRN.
Yes, the trademark is YRN. The kind produced by the company under the trademark is apparel under YRN. That's the kind of items that we produce.
And so where does Migos come in?
The original agreement for the definition of trademark, wasn't that defined to include those trademark or any simulations thereof covering the relevant goods, including clothing items, et cetera, et cetera, et cetera? Those were excluded, weren't they?
No, Your Honor, the definition of trademark covers YRN on apparel.
Right, within the YRN label.
Yes, that's what was assigned to the plaintiff, the right to use YRN on apparel.
I get that, but it also allowed for Migos to use to also market their own apparel and stuff under a different label. There is nothing in this agreement that prohibits them from marketing similar products under a different label, as your clients are able to under this agreement with other parties.
Well, I believe where 11.2C says under the Migos name, that answers Justice Mendez's question as well, where you said, Your Honor, where does Migos come in? Migos comes in the first part of that phrase in 11.2C. They agree not to directly or indirectly produce or license under the Migos name any item of the kind produced by the company under the trademark.
It says under the trademark. What is the trademark?
The trademark is YRN on apparel, Your Honor.
Okay, so long as they don't use the YRN trademark, then that is what is excluded under this contract, no?
That's not how I read under the Migos name, Your Honor, and I think you have to look at the entirety of the clause in context.
So we have to look at the entire agreement?
Yes, the entire agreement, certainly, and the
Right,
entirety
so
of
the
the clause.
context of this entire agreement, this young group, you're saying by virtue of a $150,000 contribution has given up the right to use their name and their product
No,
forever.
let me address that, Your Honor. No, let me address that, Your Honor. That's mistaken in two respects. Number one, it was not just a $150,000 payment. It was a 25% profit interest in an entity where Mr. Scher would be putting in all the money and doing all the work for years and years. And they're not giving
all
up.
of the work. I'm sorry. Wait. It's not. They may do the administrative work. Yes, I would give you that. But who is generating the interest in the label in the first place? It is the Migos.
Yes, absolutely.
Party, isn't that right?
Yes,
so
absolutely.
I don't know that I would say that your client is doing all the work.
Well, Mr. Scher had to build the business and set up all the distribution channels and the production capacity and do all that. He put in.
That was already in place, right?
No,
that was already in place in virtue, in light of, if I could finish, that distribution network was already in place. Indeed, that was probably what brought Migos to the table. They had already done deals with people like Jay-Z. So of course, I mean, that was already in place. He didn't have to recreate the wheel. He just used the wheel already in place. Isn't that right?
It's not correct, Your Honor. He did have to, he knew how to do it, but he had to set up this entire business from scratch, which he did. And on your other point, Your Honor, where you said they gave up the right to use Migos forever, that's just not factually true, Your Honor. The only thing they were giving up in exchange for this was the right to put Migos on apparel. They had the right to put Migos on all sorts of other merchandise, any other merchandise in the world. They also had the right to put their own names on even apparel. They could put their own stage names on apparel. They could put the names of their future songs and albums, pictures of their cover art. They could do all that even on T-shirts and sweatshirts. Okay. And they could use their name.
You have time on rebuttal. All right, Ms. Matz, you have 5 minutes.
Thank you, Your Honor, and may it please the court. The lower court correctly denied summary judgment and dismissed this particular contract claim here, and correctly found that the agreement did not, as the plaintiff appellant contends, bar my clients from selling apparel bearing the Migos mark. As you will note, appellant's counsel, and repeatedly in his brief, says this agreement says that the Migos can't sell Migos branded apparel. They gave up the right to exploit Migos branded apparel. Nowhere in the agreement are those words contained. The 11.2C absolutely does not say that they cannot sell Migos branded apparel. The lower court denied the motion for several reasons, one of which is that the lower court declined to agree with plaintiff's counsel that it was going to substitute the word under for bearing. It also found correctly that even if it did substitute the word under for bearing, because the last part of 11.2C says under the trademark, and if you were able to say that could mean bearing the trademark, then it would mean precisely what Your Honors have just articulated, and that is that my clients maybe would not have been allowed to sell Migos branded merchandise also with YRN on it. Appellant's counsel has tried to pretend that this was taken care of by other parts of the agreement, but that's not the case. The YRN marks were conveyed. My client clearly has rights in the name YRN long before this agreement was executed. My clients had been using the name YRN for tours. They had been using it for album and mixtape releases, which means they had under trademark law acquired rights in the name. They only conveyed certain rights in the YRN mark to the appellant, and nothing would have barred them from potentially continuing to use YRN in an ornamental fashion. And to the extent that this provision is enforceable at all, it would only be enforceable to bar them from also putting YRN on Migos branded apparel. For example, I could give the court an example of ornamental use that surely you have all seen, whether or not you've been to a Migos concert. Oftentimes bands put album covers on T-shirts. They put large pictures of the album cover. Those uses are ornamental. To the extent that there was any intent to have any restriction here, that is all that it was. Regardless, however, and the lower court also properly found this, even if it meant that, this provision is likely unenforceable because there is a trumping provision in section 3.5 of the agreement that specifically says that nothing in this agreement, nothing herein shall expressly or by implication impose any restriction on the ability and the right of the managers and the members or their affiliates to render services including the same or similar services contemplated hereby, or engage in any business venture or activity of any nature or any description for or with any person or entity except as expressly provided in 3.1b. Nowhere is 11.2c mentioned, and 3.1b does not contain any restriction on my clients using the Migos name whatsoever. This agreement was not about the Migos name. This agreement, and plaintiffs on the lower court repeatedly said to the court, this agreement was about YRN. It was not ever about conveying rights in or restricting use of the Migos trademark, nor would my clients ever have signed such an agreement to the extent that it would restrict a very, very important line of merchandise. Income stream for a band, and not just an income stream, but something that helps promote the overall awareness of a band and people knowing about them. It is not something they ever would have done. And in fact, they had already given the exclusive rights to the Migos name to their record label, Quality Control, long before ever signing this agreement. It's not something they could have done. Plaintiff's counsel.
Was this 11.2 negotiated between the parties?
No, it was never discussed, and both parties agree with that. Here we have a situation where the plaintiff's counsel has essentially asked this court to rewrite this agreement and enjoin activity that was never contemplated to be restrained, because at the end of the day, the parties went into business together and tried to build a business, and it didn't work. And so instead, they decided to try to turn around and blame my clients for the fact that a new business venture didn't work. And you know what? They don't all work out, unfortunately. Although I would like to note that we do not agree with the reasons that they have stated for the demise of the business. This motion was also filed extremely prematurely. There had only been a few hundred to maybe low thousands of documents produced. There were hundreds of thousands produced after these motions were filed. There was no depositions, although they had been noticed. So we are talking about the plaintiff asking the court to make leaping conclusions about the meaning of an agreement, and the court declined to do that, and properly so.
Thank you. Counsel, you have a minute on.
Thank you, Your Honor. 3 quick points in my minute. First, nobody's advanced any other plausible interpretation other than our interpretation. I understand you may feel this clause does not perfectly express what I'm saying, but you still have to make a judgment as to what it was intended to express. And what the court below and the respondents say is that all it means is that they can't sell YRN apparel. And it wouldn't make any sense for them to put that into an agreement and sign separately under boldface just to do that. They already couldn't do that because they had assigned the trademark to plaintiff. Second point very quickly is the defendants had sophisticated Beverly Hills counsel, that nobody was taking advantage of anyone. They made a trade-off. At a time, their manager admits at the time of contracting, YRN was the name the public was interested in. They were not at that time selling at retail any Migos branded apparel at all, much less over the internet and around the world, which they did later. So it was a reasonable trade-off at the time. And the last point, Your Honor, is it was working. It's not factually not true to say the business failed. The business was starting to take off as Migos' career took off, precisely because the public did associate Young Rich Nation with Migos. The business was starting to take off. That is in the record. Then they cut the legs out from under it by competing, by going into business with the world's largest music company. And Your Honor, thank you, Your Honor.
All right. Estrella versus East Tremont Medical Center. Mr. Gomez, you have 4 minutes.
Thank you. Good afternoon, Your Honor, and may it please the court. My name is Manuel Gomez. I'm the attorney for Mr. Estrella, the plaintiff appellant. Mr. Estrella sustained very, very severe organ damage while undergoing a routine colonoscopy. The case was dismissed in the court below because at the time that the summons complaint was filed, we omitted to also include a certificate of merit. Our appeal was perfected prior to the holding in Fortune versus New York City Health and Hospital Corporation. Under the case law of Fortune,
you have two members of that bench here on this bench, so we are quite familiar.
Thank you, Your Honor. But based on the holding in Fortune, our case should not have been dismissed, and therefore we should prevail on our appeal. Our appeal should be granted, and the case remanded back to the trial court. The respondent defendant, though, are raising additional arguments, which I would care to address at this moment. One of their arguments is that the summons and complaint is untimely because there was a prior case that was commenced in 2006, and that based on that prior case, the prior case that was commenced in 2006 was dismissed because we failed to move for default judgment against these defendants within 12 months. The judge in the lower court.
And you say, Counselor, that the CPLR 205A saves you, right?
Yes, Your Honor. Yes.
Is this the issue of whether or not service was proper?
We go to that now, Judge, then. We believe service was proper, and to the extent that it was not proper, there was no hearing in the court below, there was no testimony that was held, and relying on Engel versus Boymel Green, 88D 3rd 653, a hearing should have been required, because in this particular case, we have a process server that has an affidavit of proper service. What the defendants are saying is not that they never received paperwork. They're not saying they didn't receive, they acknowledge they received the paperwork. What they're stating is that Mr. Pierantoni, who accepted the service, was not authorized to accept service. But at no point did his office or his attorneys notify our office or the process server that he was not authorized. Where you have a case like this one, where we have the affidavit of service by the process server, and you have a conflicting affidavit, the holding an angle dictates that it necessitates a hearing. Because no hearing was held in this case, we believe that the case should not be decided at this time, but should be remanded.
You have a minute on rebuttal, and we'll hear you then. Mr. Ratner, you have 4 minutes.
Good afternoon, Your Honors.
Good afternoon.
Good afternoon. So the Fortune case is, I guess, to my misfortune regarding the merit, the certificate of merit claim. So I'm not going. I'm not going to belabor that point for sure. But you know, we did raise a number of other arguments in our brief. For one thing, the appeal should be dismissed because the appeal from the order, the interlocutory order, was never perfected. It was deemed dismissed by operation of statute, and the plaintiff never moved for another enlargement of time. Instead, they let that appeal lapse, and then they sought an enlargement of time only on the appeal from the judgment. And the case was fairly clear on that, where you don't let an appeal die on the vine and then attempt to revive it on an appeal from a judgment. And I think that I'm on fairly safe ground in making that argument. So the appeal should be dismissed. Secondly, on the issue of personal jurisdiction, the plaintiff's only response to our motion, which was based on an affidavit from the gentleman who said he may or may not have accepted some papers, that he was not authorized. He was not an agent of the corporate client, that the East Tremont Medical Center, and Dr. Renvoice certainly never authorized him to accept service. In fact, Dr. Renvoice was not even employed at the facility at the time of service. The only thing that the plaintiff said in opposition to that is that, well, they're not to be believed. That was their total showing in opposition to a motion to dismiss. That's not enough to allow for a hearing. But by the way, I think I just heard counsel say that, well, we would agree to a hearing on that issue. But so short of dismissing this action, fine, remanded for a hearing, and we'll be happy to go down that road. But it should be dismissed. It should be dismissed. Finally, on the issue of statute of limitations.
Thank you. Your time is up.
Oh,
Mr.
man.
Gomez, you have 1 minute. You're on mute if you are speaking.
Manuel Gomez here, I can hear.
Okay. You have 1 minute. Go ahead.
Am I back on again?
Yes, you are.
Thank you, Your Honor. All right, they're not citing any applicable authority as to why the case should be dismissed based on abandoning of the earlier appeal. The cases that, well, first of all, this court has a discretion to hear this second appeal if it is a second appeal. Second, the appeal of our September 3 order and the judgment merges to one. Number three, they raised the same argument when we moved to vacate the automatic dismissal of the judgment and order. They raised the same appeal, and the court denied their argument by granting our motion. And it was our intention, paragraph 12 of our motion to vacate the automatic dismissal, paragraph 12, indicated that the same argument we're making for one appeal should be applied to the second appeal. So it was never our intention to abandon anything. With regard to service.
Thank you. I think we've got your arguments. Have a good afternoon, sir.
Thank you, Your Honor.
Theodore Gambagolta, Ron Che, MD, and Staten Island University Hospital. Counsel for Dr. Che, you have 4 minutes.
Thank you, Your Honor. Good afternoon. Colin Rathje for Dr. Che. The primary issue here is the duty that Dr. Che owed to this patient and what we contend to be the trial court's incorrect finding that he had a duty specific to the single remaining claim for medical malpractice, which in this case is a failure to diagnose and treat a spinal abscess. The remaining claims were all dismissed. The trial court found that Dr. Che could have a duty with regard to this specific remaining claim because of his day-to-day involvement in the patient's care. The issue is this patient was diagnosed even before Dr. Che's involvement with a spinal abscess based on radiology. Appropriate specialists were called in, including infectious disease, initially interventional radiology, ultimately cardiothoracic surgery, all in attempts by those specialists to diagnose and treat that spinal abscess. Dr. Che was a hospitalist. He was not involved in the day-to-day care with regard to those specialty elements of this patient's care. The trial court relied on Mandel versus New York.
What Dr. Che's duties as the hospitalist?
Dr. Che's duty as a hospitalist was to manage this patient's care and to ensure that the specific care he needed was provided by those best suited to provide it. And in this case, the care he needed specific to this claim, diagnosis and treatment of the spinal abscess, was assumed, that duty was assumed by each of the appropriate specialists, infectious disease, various surgery specialties in order to diagnose and treat the spinal abscess.
I'm sorry, this is Justice Shulman. So just stated a little differently, Dr. Che, while a hospitalist, was more or less guided by the specialist. So he was taking his orders, so to speak, in the hierarchy of things, correct?
Well, I think you stated a little more strongly than that. He relied on them, not just that he was guided by them, but he relied on them. Their assumption of the duty displaced his duty to this patient with regard to that specialty care. And that is supported by cases, among others, Perez v. Edwards, which is a more recent case than those relied upon by the trial court. And Perez specifically said that, you know, a general physician is entitled to rely on specialists to provide the specialty care that they are best suited to provide.
By the way, was Dr. Che an employee of the hospital?
He was not.
So therefore, there can't be vicarious liability.
That was the finding below, and I don't believe anybody's contending that. Yeah.
So what is his relationship? Excuse me. What is his relationship to the hospital?
He has attending privileges.
And he's the hospitalist?
Yes, yes, Your Honor.
Who was he
Is he
there?
the hospitalist there, 9 to 5 or some sort of shift all the time to care to all the patients on the floor?
Dr. Che made morning and afternoon rounds. He had a private practice as well, so he would be at his private practice or he would be at the hospital. But with regard to,
Well, I mean, you characterize him as the hospitalist. Isn't it the hospitalist's job to be there for the whole for a whole shift every day or 5 out of whatever days? That's their job, to make sure that all the patients in that area that they're covering are receiving the appropriate care?
well, I'm not sure that correctly describes the scope of a hospitalist's duty, but that's not the duty that's at issue here. The duty that's at issue is very specific. Plaintiff abandoned 10 of the 11 claims. The duty here is very specific to diagnosis and treatment of a spinal abscess. And that specific duty was assumed by infectious disease consultant, interventional radiologist who initially attempted to biopsy the spinal abscess, and ultimately cardiothoracic surgery, who did drain and biopsy the spinal collection.
Thank you. You have some time in rebuttal.
Thank you.
Mr. Lee, you have 3 minutes.
Thank you, Your Honors. Good afternoon, Your Honors. May it please the court. The lower court has found that Staten Island University Hospital the lower court granted summary judgment to Staten Island University Hospital, except to the extent that it could be held vicariously liable for Dr. Morberkai. However, plaintiff essentially does not oppose this on appeal and concedes this, and this claim is essentially abandoned. Instead, now plaintiff argues on appeal that the hospital is vicariously liable for Dr. Che. As Justice Shulman just said, there is no vicarious liability for the hospital for Dr. Che. And additionally, plaintiff failed to cross appeal this issue before the lower court. So as this court has found in Pesman v. Department of Education, this court cannot grant relief to a party who has failed to cross appeal. Additionally, the hospital cannot be held vicariously liable for Dr. Che because plaintiff was admitted to the hospital under Dr. Che's care, and Dr. Che explained to the plaintiff that he was a private attending physician and that he was admitting him based on an arrangement he had with plaintiff's primary care physician, Dr. Zamfran. In sum, Staten Island University Hospital cannot be held vicariously liable for Dr. Che or for Dr. Morberkai. Thank you, Your Honors.
Why would you said that the court did not grant summary judgment as to Dr. Neville Morberkai, correct?
Yes, Your Honor.
So why would plaintiff have to appeal when they are
Your Honor,
when that is favorable to them? Did I understand you correctly?
Sorry, yeah, let me clarify if I could. As to Dr. Morberkai, which is what we appealed, Staten Island University Hospital appealed. We appealed our vicarious liability for Dr. Morberkai because that's what the law held, right? And then they found in favor of plaintiff.
And plaintiff didn't oppose.
Did not oppose.
Did
not oppose Morberkai. Now argues Che.
I heard it wrong. Yeah. Forgive me. I got you.
Yeah. Okay.
All right. No problem. Ms. Rikus, you have 5 minutes. We cannot hear you.
Can you hear me now, Your Honor?
Now I can hear you. You may proceed.
Thank you. Thank you. The defendants mischaracterize and misunderstand the underlying foundation of the plaintiff's claim. The defendants failed to administer empirical antibiotics, and plaintiff was untreated.
But Dr. Neville, the pronunciation of that name is a little difficult for me. But Dr. Neville repeatedly ordered that no antibiotics be administered. And insofar as he was indeed the
infectious
the
disease.
specialist on the issue, why was it a deviation for either Dr. Che, for Dr. Che to defer to his judgment?
It's a departure, Your Honor, because when an infectious disease as serious as osteomyelitis and discitis, which is suspected from the minute the plaintiff walked into that or was carried into the hospital on January 13th, 2014, that's a serious condition. That requires the administration of empirical antibiotics on an expeditious basis. Empirical antibiotics are in the hospital's formulary, and they don't pose as much of a risk for inducing bacterial resistance. And you start with that to try to get things under control. This plaintiff was left untreated when the proper standards of medical care and treatment require the administration of empirical antibiotics.
Counsel,
even though cultures came back negative.
Counsel,
sorry.
This is Judge Mendez. I'm sorry to cut you off, but the defense expert stated that until the organism, the precise organism that was affecting the plaintiff was identified, that it was proper for Dr. Mabarakai not to recommend the use of any antibiotics. And your expert did not address that aspect of the defense expert's opinion. So where does that leave us? I mean,
I think that leaves me looking to see what my expert said in the record. And
basically, that was not refuted. So now you're saying that because Dr. Mabarakai...
It says negative cult... I'm sorry, Your Honor.
Because Dr. Mabarakai...
1333. It's record 1333. He said, in spite of overwhelming evidence of discitis and osteomyelitis, Mr. Gambacorta was never given IV antibiotics for the infections while hospitalized.
We know that. That we know. But the expert says, the defense expert says, it was proper not to give him any antibiotics until the organism was identified. And your expert did not refute that.
Excuse me, I believe he did refute that. Record 1334, my expert says the standard of care requires the paraspinal abscesses to be drained and that discitis and osteomyelitis be treated with 6 or more weeks of appropriate antibiotics. When cultures are negative or equivocal and all of the other studies indicate osteomyelitis and discitis, treatment should be empirical in order to cover all of the likely organisms.
Does he say anywhere, I disagree with the defense expert, that despite the fact that the organism was not identified, he should still have received antibiotics?
That's exactly what I just read from the record, I believe, Your Honor.
That's not what it says.
I disagree.
I read him saying negative cultures do not rule out infection. I then read him saying when other indications indicate osteomyelitis, treatment should be empirical in order to cover all of the likely organisms, whether they've been found or diagnosed or not.
So
I believe
the expert says that given an antibiotic without identifying the organism could actually cause things to get worse, because now you can mask whatever it is that the plaintiff is suffering from. And it would be even more difficult later on down the road to treat his condition.
Well, this is your classic battle of the experts, which precludes summary judgment in medical malpractice cases, Your Honor, because it's certainly plausible and tenable what my plaintiff's expert is saying. Someone goes into the hospital with suspicion of infection. If the record shows his white blood count was well above the top of the normal limit, something was very serious was going on. Then the injuries.
So we have that is Dr. Mabarakai, the infectious disease expert, who's actually taking care of this aspect of the treatment. Did you sue him? Did you mention him in the bill of particulars?
I'm not specifically aware of that. He's not named as in the caption. But
he's not named anywhere. Actually, he's not named anywhere.
He's an employee of the hospital, correct? Because that was a ruling from the motion court that SIUH's summary judgment motion was granted and dismissed the vicarious liability with relation to Dr. Che, but not with relation to the other doctor.
But it didn't make,
Mobarakai.
it made an affirmative finding that he was an employee?
They didn't.
But
I don't believe
it was
that that's
denied.
what the court ruled.
But it was granted except to the extent that plaintiff's claims seek to hold the hospital vicariously liable for the departures of Dr. Mobarakai in failing to treat plaintiff with antibiotics during his admission to the Staten Island University Hospital.
Counsel, we have the decision, but what we have noted is that the decision does not say. There's no affirmative finding that that doctor is an employee of SIU Hospital. None. There's no statement to that effect in that decision.
Well, I'm sorry, Your Honor, but I read it differently, that the lower court
all right, look, I get it. You read it differently. It's not what it says. Okay?
It says a hospital can be held vicariously liable.
Your time is up.
Thank you. Thank you, Your Honor.
Thank you. Counsel for Dr. Che, you have 1 minute in rebuttal.
Thank you, Your Honor. Just in addition to the deficiencies noted with regard to plaintiff's expert's affirmation, what the plaintiff's expert actually said was, if all other studies indicate osteomyelitis, then you give empiric antibiotics. And the plaintiff's expert very specifically omitted the key fact, which is the major study, the drainage of over 2 cups of old blood, which was the collection on the spine. He didn't even address that occurred, much less the fact that the physician who did it had his eyes on that spine and said no evidence of infection. And the cytology immediately following that study said no evidence of infection. So even if we assume that the plaintiff's expert's opinion is correct, that empirical antibiotics should have been given if all other studies show osteomyelitis, the study did not show osteomyelitis. In fact, it suggested that it was ruled out. So even if that's the standard of care, it was met. But I don't think we even get that far. Thank you.
I think that this is contradicted on record 790. Sorry.
Counsel, you cannot do that. That is not the process in appellate court.
Sorry.
Lindenwood Village Section C Cooperative Corp. versus Seth Denenberg, Esquire. Mr. Kamens, you have 3 minutes.
Thank you. Good afternoon, Your Honors. May it please the court. The facts of this case are undisputed. After the Appellate Division, 2nd Department, issued a favorable ruling for the appellant, his attorneys, the respondents, inexplicably failed to follow CPLR 5513B to start the 30-day appellate countdown.
Counsel, I have a question. Yes. If they had served that notice of entry timely, is there any assurance that there would not have been an appeal to the Court of Appeals?
That's the speculation.
Right. So now they didn't serve it timely. So why are you saying that because they didn't serve it timely, therefore there was an appeal to the Court of Appeals? Isn't that also speculation?
Well, if you look at the case law, it says only look at the facts. And the facts are they didn't follow CPLR 5513B and serve the notice of entry. And the State Division of Human Rights, 644 days later, was able to make a timely motion. And that's why the Court of Appeals had the opportunity. Everything else is speculation. Those are the facts. Maybe they would have appealed. They would have done it, did the motion timely. Maybe they wouldn't. But if you look at all of that,
speculation.
That's speculation.
But in a legal malpractice case, Counselor, the standard is that but for their actions, there would have been a different result. And that on your part requires even a greater amount of speculation, because that's what you would have to show, that but for the delay.
Right, but the reason why I believe that the appellant is not speculating is we just have the facts, right? We know they didn't serve it at all, and 644 days later, they made the successful motion. Everything else is speculation. Maybe they would have done it, maybe they wouldn't done it. But we know if they did it reasonably timely, you couldn't file a timely motion 2 years later. I mean, if you look at the case of Lappin versus Greenberg in this court, basically the court decided that, you know, the delay of the attorney caused his client financial loss. And when
because there was a change, right? There was a change to the detriment of the plaintiff in terms of what they could have gotten had something been done timely. But that's not what's taking place here.
I mean, all I see are the facts, right? We're not the ones speculating. If you look at the lower court said, well, maybe they would have timely filed, right? She said there was no proximate cause because maybe they would have timely filed. That's the speculation. We know that they didn't timely file.
Okay, you have a minute on rebuttal. Mr. Sperber, you have 3 minutes.
Plaintiff's claims are grossly speculative. They do not show that the failure to serve notice of entry proximately caused appellant to sustain damages. Justice Mazzarelli, I'm fortunate to have read a few cases that you were the presiding justice on in this very court where you so hold that the but-for standard is required. I'm citing.
Well, yes, you have a pretty good chance of that, because yesterday I looked at Westlaw and it said I have 10,000 plus cases here, so.
All right, moving on then. Judge, there's something that I'd like you all to consider. A simple look at the composition of the Court of Appeals. If you look in 2016, in November or in December, when we could have served that order, 5 of the 7 judges are the same as there were in 2019. And one of the judges that changed, Justice Wilson, he joined on February 6, 2017, so he likely would have been involved with that motion for leave. So there's only one different judge. So, and that judge we heard the terrible news about today being Justice Feynman. But you have the same law, you have the same court, you have the same result. The decision of the court below should be affirmed. And finally, the Lappin case that is cited by my adversary, that involved the investment of pension funds. There was real loss. It was not pure speculation, because he would have to show that A, they wouldn't have given leave, and B, even if they gave leave, he would have won again. That's not the case here.
Thank you. Counsel, you have 1 minute.
Okay. As far as the Lappin case, basically the fact was that the fact that was presented was that the attorney's delay resulted in the financial loss, right? But when the defendant attorney said that, well, maybe the plaintiff wouldn't have known how to invest the funds, that's the speculation. You know, the defendant respondents bring up this idea of the Court of Appeals and the composition of the Court of Appeals. This should never have gotten to the Court of Appeals, because we know had they didn't timely file, had they complied with 5513B, there would have been no opportunity for the Court of Appeals to have heard this case, because the fact was it was 644 days later when they actually made their motion to appeal. And this case is based, again, on the second prong of the Nomura case, Nomura versus Cadwalader, which doesn't look at the underlying litigation. It looks at whether there was proximate cause and there were actual damages, and there's a direct relationship between the facts that happened and the resulting damages.
Thank you.
Thank you.
Leasing Control, Inc. as assignee of Fire Quench versus 500 Fifth Avenue. Mr. Zauderer, you have 3 minutes.
Good afternoon, Your Honor. Mark Zauderer for the appellant. Okay, if there's one thing we agree on this appeal, on the issue of champerty, which I'm going to address in a moment, there's a basic distinction between assigning a claim for the purpose of collection or assigning it for the purpose of instituting a lawsuit. Now, the argument that's made on the other side and was
is there a difference? If the purpose of the lawsuit is to collect on the debt, what's the difference?
That's permissible. This is not a distinction I made up. All of the case law, Bluebird, Justinian, all discuss the fact that there is a distinction. There's no question. But if the evidence established that the purpose is collection, that would not be Champertus. I mean, that's clear in the case law, okay?
Right. So leasing control is a debt collection entity? Is that what it is?
It's in part that. The record establishes that the company was established by Mr. Burke for his sister, who's a school teacher, as was said in Ireland, to either try to develop the business or collect. Collecting is fine. The argument, and I think the other side has not taken issue with that here. The other side has said the evidence establishes, based on Miss Ross's, that's the sister, based on her deposition, that the purpose was not just collection, it was specifically for the purpose. And the courts put that in italics in their appellate, in the decisions, for the purpose of a lawsuit. And they have cherry-picked her testimony in their brief. And what I'm going to show you in 1 minute that I have is that how they have cherry-picked that testimony. They cited page 181, where they asked her about it. They said, was it to commence a lawsuit? But what they left out was further down at record 181, line 21. So it was your plan that once the assignment was made by Firequench to Leasing Control would then commence a lawsuit on that day. And the answer was commence collection. Yes. So she talked about collection. What they've left out in addition is at page 170 her testimony, where she says, as I've just indicated, Leasing Controls was set up by my brother in the latter part of 2012 to deal with collection issues for Firequench and also some firm alarm business, which didn't work out. And finally, page 174, question, and he had asked you to take over a company whose business had been envisioned to be developing a fire alarm business? Answer, fire alarms and collections. And if you look at the assignments that occurred in this case, you will see that it was for all purposes. There's no doubt about that. Paragraph 2 of the assignment at page 69. So I think what's been presented is a distorted picture. And finally, I want to point out an irony of this case. Look, I've been doing this 50 years. I don't think I've ever seen a Champerty defense except but once. And in that case, it was asserted an affirmative defense, and we all went to the law books. What we have here was the following. This was very clever by the other side. And this is how this result is entirely not only
Counsel,
wrong,
you have 30 seconds.
I will do so, but unjust. The answer at page 34 of the record on April 30th, 2013, had only a bunch of boilerplate defenses, including plaintiff's lack standing to assert these claims. The Champerty defense was only presented in 2019 in July in the summary judgment motion. This would have not have given notice to the defense. And at that point, if we had wanted not to contest it, there was no opportunity to make the assignment back. And the defendants knew this. And they had an obligation to present this as an affirmative defense, which is supposed to give notice. It was never done. Thank you.
Mr. Smith, you have 3 minutes.
Thank you, Your Honors. First, the proposition that there is a blanket exception to the Champerty rule if you simply state that the purpose of this entity that's the assignee is to collect on a debt would eviscerate the entire Champerty rule. It's very clear that in all cases of Champerty, the purpose has been to take that debt and collect it in some fashion.
Counselor, I'd just like you to address Mr. Zouder's last point. Is Champerty an affirmative defense that requires notice?
I do not believe that it is a affirmative defense that requires notice, and I would like to address the inequitable conduct argument. So thank you for that. The inequitable conduct argument was never made to the court below. It was never briefed in the opening brief on appeal. It appears for the first time in the reply papers submitted on this motion, on this appeal. And it bears, therefore, examination of what the timeline shows us. When the lawsuit was started, this involved a series of invoices that were supposedly rendered and represented work supposedly done, hotly contested. The entity that had done the work, Firequench, had done construction work at the building and had been paid in full and signed off on waivers by 2009. They were fired and then removed from the building in 2012, and that's when they showed up with a box full of documents, invoices dating back to 2006, 2007, and 2008. They filed suit in March of 2013. Now, at that point in time, they'd already blown the statute of limitations with respect to the years 2006 and 2007. And as recounted in our moving papers, and it does bear review. We submitted an affidavit which describes the delay that occurred throughout this case. 5 different law firms have touched this case. Mr. Zauderer is now the 6th coming on board. And in each of those periods of time that one law firm after the other was there, it did nothing to advance their case. In 2013, after they filed it, they had already blown the statute of limitations for a substantial portion of those invoices. There was no activity in 2014 by the first law firm that brought the case. They withdrew because they hadn't been paid, and they said that their client was not assisting in discovery. In 2015, a new law firm comes in. They likewise.
Counsel, you are almost out of time, so we can't go through the entire litany of the procedural history of this case. Are there any other substantive arguments you want to make before your time runs out?
I think the important point, Your Honors, is that the assignment itself was never even produced until 2017, at which time virtually all of these invoices were no longer within the statute of limitations. So the inequitable conduct does not lie on our side of the ledger. It's on theirs for having dragged out this case and brought a case with a time period that had already expired.
Thank you. Mr. Zauderer, you have 1 minute.
Thank you, Your Honor. You know, there's an old saw about it. You can't applaud with one hand. What's been left out of this presentation from my colleague is the following. First, on the statute of limitations, he says, well, part of it would have been lost anyway. Well, the services were performed here from January 2006 to December 2012. That's at the record in the complaint at paragraph or record 25. So while he says part of the claim might have been lost, there was a substantial portion of this claim where the services went up to 2012, and the case was then started, in 2013. The second point I want to make here is that where the merits of the suit are not before here, but the ironic result of the argument my colleague is making is we'll never get to the merits of the suit. And the fact that the case took a long time and had a number of lawyers in it, which was for me, is irrelevant to the point. The point is that they didn't raise an affirmative defense, a defense of champerty. They had the assignment before it. They had the ability to establish the facts, and even didn't do so with an amendment to the complaint. If they found out about it years later, they could have moved to amend the complaint. We could have argued prejudice, or we could have dealt with it in the case, but they never did that. It only came up in the motion for summary judgment, and that's where it left the respondent or the appellant here essentially unable to respond.
Counsel, could you tell me which citation states specifically that champerty is an affirmative defense that must be pled?
I did not cite a case for that, but it's basic New York civil practice law, and I can assert.
Okay, okay, got it.
Must be asserted.
Got it. Okay, thank you so much. Everett Drawn versus Al Roca et al. Mr. Valto, you have 6 minutes.
Yes, thank you, Your Honor. May it please the court, Your Honor, this appeal is based on several issues. Number one, this was a pre-answer motion to dismiss. During the pendency of this pre-answer motion to dismiss, the plaintiff appellant, Mr. Everett Drawn, we filed an amended complaint in this matter. Once that was done, 2 errors occurred. First of all, the clerk's office in this matter returned our amended complaint for corrections erroneously. There were no corrections to be made. The clerk who returned it.
We're familiar with the tortured procedural history here, but as I understand it, Judge Khan considered all of those items, and so all of the issues with regard to the items that were not considered were considered by Judge Khan, were they not?
No, they were not, Judge. Judge Khan used Judge Hagler's previous denial, dismissal, as law of the case in this matter. We filed a motion to vacate the judgment, stating that based upon these errors, and the errors were admitted by the court, Judge Hagler, and by the clerk. But when Judge Kahn decided, looked at the case, he started immediately from a law of the case position, and that all these other matters had been resolved. We cited case law that shows that once we filed that amended complaint, the original complaint was gone. It's academic. Any of the reasonings or any of the rulings by Judge Hagler were wiped out. Basically, it's all academic. We should have started from phase one, and our motion to vacate should have been the operative motion for Judge Kahn to consider. He did not consider it. He went straight to, well, all right, these first four causes have been considered by Judge Hagler. I'm going to accept that as law of the case. Let's go from there. And that's and based upon that, Judge, he never actually listened to our argument on fraud. He never listened to our argument on statute of limitations. He deferred completely to Judge Hagler, and that ruling was superseded by the filing of the amended complaint. Okay, Mr. Jones has never had his day in court in this matter, neither in Louisiana proceedings or in New York. All right,
Counsel, wasn't it determined in Louisiana that the release was a valid release?
It was determined, but it wasn't a full and fair hearing, Your Honor. We cited, we provided in the record and in our reply brief. At the time of that hearing, the defendants had refused to give us discovery prior to the hearing. They put it in writing that they would not give us discovery prior to the hearing. They didn't give us discovery prior to the hearing. In fact, the day of that hearing, we had a motion to compel discovery, which was later granted for us.
But ultimately, the court in Louisiana determined that the release was a valid release.
The Fifth Circuit Appellate Court determined that based upon, they say, the evidence which was presented. Mr. John never had, he couldn't testify to the duress.
Okay. So, but now here we are in New York. What are we to do with that determination from the Fifth Circuit Appellate Court in Louisiana? Right. Should we simply take it and tear it up and throw it in the garbage? Or are we required to somehow give it full faith and credit and say, we're bound by it? They've already determined it over there.
Defense on collateral estoppel in this case, Judge, we're saying, and we put the transcript in the record, there was no full and fair hearing. Mr. Jones,
counsel, is it not accurate that it was your client who brought the proceeding and commenced the proceeding in Louisiana?
Correct.
So you submitted to the jurisdiction of that court, and now because your client disagrees with the procedure, how it went, the ruling, whatever, now we should just disregard it, as my colleague just said?
I would say this, Judge, we don't have to disregard it. We can, if we want to accept it as true, we can. We want to give it full faith and credit. We still need to address the fraudulent scheme that was initiated in this case by the defendants. I mean, even if we throw out the duress part, we have to address how did they even get him to sign this alleged release. They invented a warrant that doesn't exist. They've admitted to it in a discovery in Louisiana. They've never denied that. They've never denied that they fraudulently obtained this alleged release from him based upon their own actions. So, I mean, even if we give the court in Louisiana the full faith and credit, they still haven't addressed the fraudulent scheme in this matter. And they've never denied it. They've never denied that they engaged in a fraudulent scheme. They've never denied that they forced him to sign this alleged release. They've never denied that they had no warrant to even drag him out of his house at gunpoint. If you see, we submitted the video in the record. They never denied any of that stuff. All they're trying to say is, all right, well, the court ruled, and now we want to just hold on to that without looking at the actual procurement of the alleged release, which was by fraud, which was at gunpoint, which was without his consent.
But again, you see, you went back to the procurement of the release.
Right.
How is that not totally connected to the ruling of the Louisiana court?
Because in the ruling in Louisiana court, it was never discussed about them having no warrant to even drag him out of the house to try to force him to sign the release. That was never discussed in the Louisiana ruling. It was only strictly on the duress and the actual alleged signing of the release.
Well, the signing of the release was in the context of him being dragged out of the house, was it not?
Right, but when defendants talk about a separate fraud in this case, Judge, that was a separate fraud. We can't start from a contract in a case like this, release. What the separate fraud that preceded the alleged signing of the release was the fraud of the defendants claiming that they had a warrant from Mr. Drawn for grand theft auto, which they admitted they never had.
Thank you. All right. Mr. Stratcher, you have 5 minutes.
Thank you, Your Honors. Your Honors, all of these arguments that are being made by the appellant right now were all presented to the court in Louisiana. There was an evidentiary hearing. The plaintiff appellant argued that the release
Quite
was
frankly,
procured
that's
by...
the only thing saving you, counsel.
I'm grateful for that, Your Honor. We have an evidentiary hearing where these arguments were made, witnesses were called, there was...
This is Judge Mazzarelli, excuse me. I'm just a little puzzled why, if ultimately the Louisiana courts decided they had no jurisdiction in this matter, which I think you would concede they didn't, it belonged here in New York. Why should they be able to decide such a fundamental issue in this case?
Because that issue was crucial and was that was the crucial issue.
That's
that they
the
had
point,
to decide in
Yes,
order
that's
for
my
them
point.
to come here. But why did they decide that, or why did they have to decide that?
Well, my point, jurisdiction, if you don't have jurisdiction, I don't understand how you can decide anything.
The parties had contractually agreed to a forum selection clause in New York.
Right.
And we had a contractual dispute, a dispute over whether the terms of that forum selection clause governed. And the plaintiff, the appellant argued that the release itself was invalid and the forum selection clause should not be honored.
Correct me if I'm wrong, please. I was my understanding that the Louisiana court actually said they didn't have jurisdiction. A forum selection clause is a little different. A court can still have jurisdiction and you can be in the wrong forum, but this court said it didn't have jurisdiction. Am I right or wrong about that?
No, Your Honor. There was no dispute about jurisdiction. The parties were before the court. We never argued that there wasn't personal jurisdiction over the defendant entities in Louisiana. We argued simply that there was a forum selection clause where the parties had contractually agreed to bring any dispute in the state of New York. And ultimately, the Louisiana court held in our favor.
So should that issue of whether the forum selection clause was valid, should that issue not have been decided first before the Louisiana court actually engaging in a fact-finding issue, as you said, of a crucial issue in the case? It is the central issue, certainly before us today. And the court before the decision of whether the forum selection clause should be honored, engaged in a fact-finding process. It seems like they put the cart before the horse.
Your Honor, this was a procedural quirk of Louisiana procedure, which I became familiar with. This is called a declination of improper, a declination of improper exception, where under Louisiana procedure, an exception of improper venue. Under Louisiana procedure, there is an evidentiary hearing that is required to be held pursuant to the Louisiana statute. And so the court must take evidence and must have a hearing. And we actually had a trial. We brought down our witnesses. We flew them down to Louisiana. They took the stand. They were examined and cross-examined. And then the court made an evidentiary finding. That is required under Louisiana law. That is part of the Louisiana Code of Civil Procedure.
And the issue at that hearing was what?
The issue at the hearing was whether the forum selection clause was enforceable, and whether because it was a part of the release, and the plaintiff argued that the release was invalid that it was obtained by duress and fraud and coercion, that he had a gun held to his head, that he was dragged out of court, that he was forced to sign it. He didn't know what it was he was signing. They had a handwriting expert come in who testified that his signature looked consistent with somebody being forced to sign something under duress. There was it was a whole full day of evidence and testimony. And at the end of the day, actually the trial court found against my clients, and it went up for de novo review to the Louisiana Appellate Court, and the Appellate Court ruled, reviewing the same evidence, the video and all the testimony, the Appellate Court ruled that the trial court erred and that there was no evidence of coercion or duress. As the Appellate Court said, the plaintiff may have been frightened. It may certainly not have been a comfortable situation for him, but it did not rise to the level of coercion, duress, fraud, all the things that the plaintiff had argued.
Thank you. And that's the issue that we have here.
That's the issue, at least as far as the validity of the releases goes. Even if this court were to find that the releases were somehow invalid, we still have the statute of limitations issue. The case was, these claims are 9 years old at this point, and that was an alternative ground for Justice Kahn's decision. And by the way, Justice Kahn did not simply rubber stamp Justice Hagler's decision. Justice Kahn said, I will view the record anew, and he did. And even if the release and the statute of limitations didn't bar the plaintiff's claims, those claims are barred because they lack merit. The essential elements have not been alleged, and that issue was not even raised or addressed by the trial court. Thank you, Your Honor.
So much. Mr. Valto, you have 2 minutes.
Yes, Judge, thank you. The defendants in the Louisiana action, and they submitted, actually agreed that the issue of duress can only be argued in New York. That was the basis of their exception for improper venue. It said, and we cited in our briefing and our reply, they stated emphatically in their exception and in the motion to continue that the defendant may argue duress, but only in New York, not here in this court. All right.
So you're saying that that was not part of the hearing that was held in Louisiana?
No, I'll tell you this. Mr. Drawn never testified to duress. We have an affidavit in the record. He couldn't even be present to testify. So we never heard from Mr. Drawn. The person who experienced the duress, he was never there to testify. And on top of that, the defendants had never answered our discovery. We cited that and briefed that below in the motion court. We shouldn't have never even, we objected to the hearing even proceeding because they hadn't given us the discovery. He wasn't able to be there and so on. But I think
did the court deem your client's absence a waiver of his right to testify?
No, he did not. No, they did not, Judge. And in fact, the court granted our motion to compel, which was held the same day of this hearing on their exception. Right after he ruled against them, he ruled and said, all right, and give them, we're going to grant the motion for compel discovery. So the court clearly anticipated the matter going forward in Louisiana.
Got it. Okay. Thank you.
Thank you, Your Honor. Thank you, Your Honors.
Conway versus Kaplan. Counsel for Appellate.
Good afternoon.
Good afternoon. You have 3 minutes.
Thank you. In December 2015, respondent published a website called LisaConwayAllure.com, the worst broker ever, which made false allegations of fact in which he essentially admitted at deposition was for the purpose of injuring Ms. Conway in her trade, business, or profession. Ms. Conway sued for libel. She later moved for summary judgment that it was libel per se. Reviewing extensive fact evidence and drawing all the inferences against Ms. Conway, which was proper when she was the summary judgment movement, Supreme Court denied the motion. Supreme Court said in dicta that pure opinion is not actionable libel. That denial of summary judgment is not on appeal, but it's important because over a year later, respondent moved to dismiss and Supreme Court incorporated the prior dicta as law of the case to find that there was no actionable libel and dismissed Ms. Conway's libel claim. That was error. Under the standard familiar to all of us, a motion to dismiss under CPLR 3211 is limited to the pleadings, it assumes the allegations in the complaint are true, and it draws all inferences against the movement. by incorporating a fact analysis from
Counsel,
the
on
denial.
a libel per se, isn't that an issue of law?
It is an issue of law, but that was not the portion of the prior decision that was incorporated was not simply that it was not libel per se, or that it was that there were issues of fact regarding whether she could prove libel or not. I will note that the motion denying summary judgment actually noted that there were facts alleged on the website on which the opinion was based, and it was not before the court whether there was whether she'd stated a claim or it was a motion to dismiss. Ms. Conway was asking for summary judgment that it was libel per se, and she lost that. But by incorporating that fact analysis into a motion of dismiss, essentially the Supreme Court drew all inferences against the non-movement, drew all inferences against Ms. Conway, which reversed the appropriate standard under CPLR 3211. Moreover, it was not a proper use of the law of the case doctrine because respondent's website, whether respondent's website was pure opinion, was not a matter that was necessarily decided in the summary judgment denial because it wasn't really before the court. Therefore, it was just dicta. It was not capable of being law of the case since it was not necessarily decided. So that's the first decision that's appealed. Then Ms. Conway moved, inter alia, for leave to amend the complaint to add a claim for breach of contract.
Why was there such a delay to add that to the complaint, which was obvious from day one?
Yes, well, I think that was a decision based on the fact that there were a breach of contract action needs to have concrete showing of damages, whereas libel per se has presumed damages. And at the time the action was brought, the situation was not as clear as when the motion to amend was made, where there was a clear case for damages because Ms. Conway's career has been severely damaged by this website. So she moved to
the record does not really bear out a lot of detail on that point, does it?
It does not, Your Honor. And I don't think that, the standard, the legal standard for motion to amend is that it's freely granted. Ms. Conway.
Counsel, not when the motion to amend is made on the eve of trial after 2 years of a complaint. We're not talking about a motion to amend at the beginning of a case. This case was on the eve of trial. That's a totally different situation.
It is it's also a very unusual time to make a 3211 motion to dismiss. Admittedly, all of the procedure is quite strange. But there was no rationale given for Ms. Conway's, for denying Ms. Conway's motion to leave, for leave to amend the complaint. She and the respondent did have a prior dispute, which was settled in 2015 before respondent had published his website. So since that settlement agreement included a non-disparagement clause, there's an obvious cause of action.
How long after the settlement did this website go up?
Excuse me?
How long after the settlement did this website go up?
I believe the settlement papers were signed in July 2015, so that would be five months after. The case was discontinued in August 2015. Okay. And the website went up in December 2015, Your Honor.
Go ahead.
Does your amended complaint have a cause of action relating to a breach of the stipulation of settlement?
That's correct, Your Honor. That was exactly the claim that we wanted to bring. The facts were alleged in the complaint.
Is there a claim for a breach of the stipulation in your amended complaint?
Excuse me?
Is there a clause of action for a breach of the stipulation in your amended complaint?
Yes, Your Honor. It's a breach of contract claim based on the breach of the stipulation of settlement of the prior action, the action that was settled in July 2015.
Is your amended complaint the one in the record at 153 and thereafter? Is that the amended complaint that you placed before Supreme Court?
I believe that would be it.
That would be it.
Sorry, it would be a second amended complaint. So no, I apologize.
It's a second amended complaint.
It's a second amendment, yes.
And
sorry,
where would one find that second amended complaint?
Why don't you take a look, and on your time on
Your
rebuttal,
Honors,
please answer.
this is
Do you have
Dan
it?
Ditchweiler, the respondent. I know it's not my time to speak, but to assist the court, it's at 3:31.
Thank you, sir.
Thank you.
Okay, you'll have time on rebuttal unless Judge Mendez, you have a follow-up question. I'll let you ask if you do.
No.
No? Okay. Counsel Ditchweiler, you have 3 minutes.
You did wonderfully, Your Honor. Thank you for pronouncing it properly. Thank you, Your
I'm
Honors.
trying. Not a good day for me today.
It's okay. The proper pronunciation is Dan. Thank you, Your Honors. May it please the court. Plaintiff herself admitted that the statements made in Kaplan's website were opinion, and that's what the court below found in denying the motion for summary judgment. And it was entirely appropriate with the same
Counsel,
judge.
that goes, of course, to libel, defamation. But if there is a cause of action for breach of the stipulation of settlement with a non-disparagement clause, is that the same analysis?
In large part, it is, Judge Mazzarelli. The reason I say that is because if what was stated was true, it can't be disparaging. And that's exactly what was stated to the New York Post journalist who published that in the New York Post. Interestingly, the plaintiff goes out.
Wait a minute.
and
You're
speaks with the New York-
arguing that truth automatically equals it's not disparaging? That's not accurate.
Well,
I mean,
not-
it may be truth, but it can still be, it can be both.
Well, it certainly is not actionable because ultimately the court below found that the concept of, quote, the worst real estate broker ever was signaling to a reasonable reader that its raison d'etre was pure opinion, which it was.
Yes, but that's my point. I mean, that's where I'm, that concept of opinion relates to a defamation and a libel claim, as I'm sure you know.
Yes, Your Honor.
I'm talking about the breach of the stipulation of settlement with a non-disparagement. An opinion can be disparaging. A fact can be, the recitation of a fact can be disparaging. Sometimes the truth is the most disparaging. So where does that leave us?
Your Honor, it leaves you with a plaintiff who failed to raise that issue in the original complaint. They failed to raise it when they were given leave by the court in 2018 to amend the complaint. And it was only after the case was dismissed on a motion to re-argument that they threw in yet a second amended complaint making that claim. I believe that
Are you
it really
saying that
served.
none,
I
are you,
apologize.
counsel, are you saying that none of the pleadings in the original complaint, the amended complaint, that nowhere in those pleadings was the fact of the prior action and the stipulation of settlement and the non-disparagement clause, they were never mentioned in any of those documents?
No, Your Honor, they were in fact mentioned in those documents, and that was in fact, I believe, admitted by defendants in the answers. But
Okay.
what was not included in those complaints.
So there's no
what was not
prejudice.
included-
There's no prejudice that was the source of this conflict between these two parties, right?
It's not for defendants to make a plaintiff's case through their pleadings. And I think what I'm trying to express is that they had plenty of opportunity, and they never even sought that leave until the case was actually dismissed. And, frankly, I thought that the interlocutory appeals were improper from the get-go. That's the reason you have a supplemental record before the court. And the reason is that Mr. Mukherjee is correct that the original notice of appeal from the denial of summary judgment is not before the court today, but it was actually a part of the record that was presented in the supplement to the court. And that's relevant. They had their opportunity to litigate this case, and they, in fact, did it as an afterthought in the motion for re-argument.
Well, I mean,
And-
based on your adversary's initial argument in response to my first question, why this claim was not asserted earlier, it seemed that he posited a strategic reason for pursuing the libel per se route rather than the breach of contract route. And so, again, in light of that, and in light of the fact that the facts concerning the underlying facts that are the basis for the second amended complaint are not a surprise to you, and the fact that your client settled the case with a non-disparagement clause and then proceeded to create, upload, and publish a website that did just that. Why should, in the interest of fairness, that case not be allowed to be litigated on the merits?
It was litigated on the merits in this case, and I believe that it was, in your opinion, you see it as being disparaging on its face. I disagree with Your Honor on that. I believe that it was essentially pure opinion that was supported by facts, and in Steinhilber is barred by it in this court by case law.
I don't disagree with you. I don't.
And you're talking about the contract case.
Counsel.
That
Counsel.
Yes, Your Honor.
Please.
I apologize.
I don't disagree with you. So I want to be clear for the purposes of the record here. I don't disagree with you that these statements were based on facts, et cetera, and opinion. But that's not the end of the analysis for me. The issue is, did he agree not to make statements that would disparage the other side, even if those comments would be, in his opinion, true?
Mr. Kaplan is blind. He doesn't see at all. He signed that agreement being told by his counsel. And in fact, there were portions of the deposition where questions were asked concerning this. Now, I'm not suggesting to Your Honor that he didn't have a general awareness of it, but on the day that he created the website, he may not have had a specific recollection of that. And that may not be an excuse to Your Honor, but I'm telling you that his blindness does weigh into how this court should perceive what happened here. And ultimately, if you were to give—
Counsel, on cases where people who have no attorney, can't read in the language that a contract is written in, sign it, we oftentimes hold people to those contracts, right?
In many instances, that's correct.
Okay.
And I remember my old times with Hertz agreements that if you've achieved a certain grade, that you're presumed to understand what's in the agreement. I will also point out to the court that the plaintiff always had the opportunity to go out and buy a second index number and proceed had they chosen to do it. And that's what makes their last-ditch effort on the motion for re-argument that much more bitter to me. And I will rest on my brief. Thank you, Your Honor.
Thank you so much. Okay. Mr. Mukherjee, did I say it right?
Mukherjee, yes. Thank you, Your Honor.
Mukherjee. I tried. You have 1 minute, sir.
Me and counsel both are difficult here. It's a good point that we do still have time within the statute of limitations to go by a second index number on the breach of contract, but in no way would that promote judicial economy. All of the facts that are relevant to the defamation claim are also relevant to the breach of contract claim, and they've been fully discovered. We have all the documents we need. We have all we don't need to do more depositions. So that it would just be a huge waste of judicial resources and party resources to have to go, create a whole new case and go through every step of it along the way. It is very important to note that because not only did Mr. Kaplan sign the agreement with the non-disparagement clause and then create the website disparaging Ms. Conway, but so he was obviously on notice of the elements of breach just from that. But the elements of breach were essentially pled in the first complaint, the amended complaint. The second amended complaint just puts forth a cause of action for breach of contract and sort of formalizes that. So there's certainly no prejudice at all to the respondent in having that case and having that cause of action leveled against them. Thank you, Your Honor.
Thank you so much. Good evening. This concludes the session of the Appellate Division, First Department. Good night, all.
All right, thank you.